So if you're an immigrant and you pay attention to what's happening in the space, you know that there are quite a few lawsuits currently against certain law firms alleging that these law firms were filing VAWA petitions and T Visa petitions that were not legitimate. You can go Google it. You can go find out who they are. Here is the point I need to make right now. VAWA is still a legitimate form of relief. If you are eligible and you're screened properly and thoroughly and you meet the eligibility requirements, you can still file. The same for T visas. Do not be discouraged and do not feel dismayed because now all of these cases are under attack and people are worried. Here are the requirements for VAWA, and this is what you have to show. You have to show that you are married to a U.S. citizen or a green card holder. Doesn't matter if you're separated, and if you're divorced, you have to show that you're filing before the 2-year deadline. You can also file VAWA if you are the parent of a U.S. citizen 21 or older. You do have to show abuse, extreme cruelty, physical, emotional, psychological, or physical. It doesn't have to be physical, but physical can be one of it. If you are a child and you have a U.S. citizen or green card holder parent, you can also file VAWA if you're under 21. If you are the parent of a child that is being abused, you're also eligible. So those are the categories of people that are eligible. The second thing that they look at is, have you, as if you're married to a U.S. citizen or green card holder, or even as a parent or even a child, did you live with the abuser? In December, the Trump administration came out with very, very, very strict guidelines and a new policy manual that says you have to show that you lived with this person during the qualifying period. So you want to make sure that you can prove either by, bills, letters, lease, you got to show that you live with this person. You have to have a bona fide relationship. Obviously, with a parent and a child, that's really easy to show. But if you're married to a U.S. citizen or green card holder, you got to show that the marriage was real. Did you live together? Did you have any assets together? And this is all a stricter standard, which was never really the case. In the past, anything that our clients did not have, we just easily explained in the declaration, because when the VAWA statute was actually implemented and when it was authorized, they understood that victims typically do not have access to information. And so they allowed for them to use whatever they had as long as it was credible. The guidance that came out in December makes that a lot harder. And then finally, you got to show that you have good moral character, that you live in the United States. If you do not live in the United States, we have to show that your abuser is either in the federal assignment or in the military, but mostly in the United States. And we also have to show that overall, there are no crimes that would bar you from showing that you have good moral character. So again, I have handled these cases for 15 years. VAWA is what we do. We do VAWA, we do marriage green card, we do T visas. You can still file. Do not feel as though now applications are going to be automatically denied, because there is still a statute that's still valid and you can still file your cases.